Aloha everybody, I'm shooting this video. This is for the guy who says, I only shoot these videos in my bathroom. This is for you. Now, at least one more substantive video about the Tory Lanez Meg Thee Stallion trial, which I think is important for everybody to hear. But before I get to that, I want to talk about the craziest theories I've heard, especially reading the comments on the last few posts, because I go through all of them. I love all the comments, and I appreciate everyone following me and listening, because I think it's important. But let me go through each one of these theories, because I think some of them are ludicrous. Number one, the idea that Sean Kelly said something, and because he said it, that means there's reasonable doubt. He must have said it, so therefore it's reasonable doubt. This is what you have to understand. The jury does not have to believe Mr. Kelly. They can listen to what he say and throw it out. They can think he's making it up. They can think he misperceived it. They can think that what he decided to do is change his entire story or lie. Or they don't even have to think he lied. They can think he just didn't think about what was going on at that time. So for all these reasons, just because Mr. Kelly something doesn't mean there's reasonable doubt in the case. The jury can listen to what he says and throw all that out. Number two, because there's some evidence these women got into a fight, that gives Kelsey some motive to shoot Meg, and therefore there's some reasonable doubt in the case. This is what's important about that. People get into fights every day, and people do not end up getting shot. Yes, people get into fights, and people do end up getting shot after they get into a fight, but it doesn't mean that's the necessary conclusion. A jury can absolutely believe that there was a fight, and they can believe even after the fight, no one shot each other. And that's reason and common sense, because in your life, throughout history, if not in your daily life, you've seen people get into fights, and you've heard from both these people the following week. Sometimes they come back to being friends, but you've heard from both these people the following week about who started the fight, what the fight was about, what was going on. It does not mean that they had to shoot each other. It's silly. I don't mean to keep harping on Kelly's testimony, but the interpretation of it is driving me crazy. People keep saying there's a flash of light near the female, who everyone interprets to be Kelsey. She then moved away, and the rest of the flashes of light, interpreted to be muzzle flashes, were near Tory Lanez. All that means is she moved away from the person firing the gun. It does not mean that she had the gun and the other person did not. And no one said the gun was in her hand. It can absolutely be interpreted to be Tory had the gun, and she moved away as soon as he started firing, which is reasonable. It makes perfect sense. The other thing that's important to remember is I've heard someone told me that it's a reasonable defense of others that Tory had to shoot the gun. And the reason he had to shoot the gun was to defend Meg from Kelsey shooting the gun at Meg. But here's the thing. Once Tory took the gun in this series of events, I don't think this happened at all, but had this happened, once Tory took the gun from Kelsey, the problem is stopped there. There's no more reason to use deadly force, which the firing of a gun is always deadly force. The brandishment of a gun is not deadly force in certain jurisdictions. In my jurisdiction, I'm not sure about California. Certain jurisdictions, but the firing of the gun is always deadly force in most jurisdictions. So once he takes the gun from her, there's no more deadly force threatened. The problem is neutralized. You're not then allowed to turn around and shoot, and you're not allowed to shoot the person who's being threatened as a way to defend the person from being shot. Are people really hearing the defense that they're trying to run? He took the gun from her and then shot as a way to defend her from getting shot? This doesn't even make sense, especially when there's another person right over here he could throw the gun to. He could throw the gun in the bushes. He could put it in his pocket. He could do any of these things. And clearly it's unbelievable that any of those things happened. And had it happened, it didn't happen. You guys got me out here arguing for someone to be guilty. This is not what I do. I'm the person who puts videos that say Justice Smollett. I still believe Justice Smollett, that he's innocent. I'm the one who told you guys about how Bill Cosby on his appeal is what was going to happen. You know what? Let's talk about the appeal. For people who dislike Tory Lanez, this might be part of the video you're not crazy about. I do think he may have very serious, very real appeal issues in his case. Think about it like this. Kelsey's statement from September came in before the jury. They heard the whole thing. There's only two ways evidence can come in. Did I go over this before? There's only two ways evidence can come in. It can either come in for substantive matters or can come in for impeachment. If it comes in for impeachment, you can use that to judge the person's credibility. You can use it to judge to see if the person is lying. But you cannot use it to say what actually happened at the event. You can't use it for the truth of the matter. You can't rely any of the facts on that part of the statement. I still have gotten conflicting reports, one from someone who was in court and one from other people. So I'm still confused about why the statement, I know why it came in, I know why the judge made his ruling, but her ruling, excuse me, but I'm not exactly sure if it was for the truth of the matter asserted, if it was for another reason. If it was for another reason, and the jury heard 80 minutes of Kelsey blaming Tory, that could be a very potential appeal issue. Now, the jury will be told very clearly you cannot use this in a way to say Tory's guilty. You have to use it only for a specific limited purpose. I think in this case, the limited purpose was for the purpose of understanding if Kelsey was pressured to make her September statement, that kind of thing. These are all limitations which the judge can put on it. Okay. But the real question there is, can a jury, even with those limitations, even with that instruction to follow those limitations, can they follow that? I don't know that they can. I really don't. I think that may be a real appeal issue, especially if it was brought in for the wrong reason. Now, if the evidence was brought in for the truth of the matter asserted, my understanding is it was brought in after Kelsey stepped down off the stand, and the defense never had a chance to cross-examine Kelsey about the contents of the statement once it was played. If they never had a chance to cross-examine Kelsey about the statement once it was played, that could be a very serious foundational issue, which may be reason for an appeal. Now, there may still be a wealth of evidence to find you guilty, and that may stop an appeal from being granted as far as him having the judgment of the case overturned. That being said, if there's any reason for appeal that I hear from the evidence that's been reported, the admission of that 80-minute statement and why it was admitted and what the instructions were and how it was being used, my bet is any appeal is going to be focused on especially that particular issue. The one about what are we supposed to do, there's no DNA, there's no fingerprints. In gun possession cases, they use DNA and fingerprints. Fingerprints and or DNA is found in less than 10 or 15% of cases, at least according to the articles I read based on this. I've never heard of them finding DNA in a gun possession case. They almost never need that, especially because even if they find DNA in the gun, if the person held that gun in a legal location, for example, at their own home or in a different situation before the numbers, for example, in this case, I think it was unregistered, before it was unregistered or before the numbers were filed off of a gun, for example, then what does DNA prove at all? It doesn't prove anything. So since it's in so few, it's a red herring. It's not an issue in a case like this. Can we talk about something? Let's talk about something interesting, a more interesting case. As long as we're talking about rap law and rappers in the law, let me talk about a case which I find way more interesting, which is brand new. And if my understanding is it's filed today as I filmed this, I think it's just been reported on. Black Sheep, if you guys remember the rappers from the late 90s who were amazing, Dres of Black Sheep, filed a lawsuit with the Viscosity. Their lawsuit is about, I believe it's Universal Music Group signed an agreement with them that said they would get a certain amount of money based on royalties on future uses of their songs. So this is way before streaming had anybody had ever imagined. So they would get 50% of whatever it was that they should get in future uses in streaming. But this is where it gets interesting. What ended up happening is that Universal Music Group exchanged with Spotify partial ownership for a lower royalty rate. So what they did was they negotiated away the money they would get per song for royalty in exchange for ownership. Well, normally what that would mean is, and what they've interpreted as, is they give the artist the same amount of money they always got from a royalty rate, but since the royalty rate from the Spotify is lower for streaming, the artists get that percentage lower based on it. But Black Sheep's contract said they get 50%, so it's actually a higher rate of everything in the future. If it's proven by Black Sheep and their attorneys, and I think they're filing this as a class, they're trying to get other artists on board with it. If it's proven what UMG did, what Universal Music Group did, if this is proven that they exchanged ownership in exchange for a lower royalty rate, Black Sheep may actually be entitled to owning part of Spotify. Whatever the ownership they received in exchange for lowering that rate, UMG got that ownership because of the music, the songs, the intellectual property that UMG had from Black Sheep. So to me, this is a fascinating case based on the initial paperwork. It's honestly open and shut as far as that goes. Now, it should be open and shut at this point. This is what people aren't getting about lawyers. When a lawyer puts forward their case, it should read open and shut. Like, it shouldn't be an issue like maybe something's going to happen, because if you do that, you're wasting your money, you're wasting your time. Let's see what the response is from Universal Music Group, who I'm sure has an amazing amount of lawyers, or if they settle for something, see what happens. But let's see what the response is. For it to get to this level, let's be very clear. For it to get to this level, there's been intensive negotiations about this for at least 2, maybe 5 years. They've been talking about this for a long, long time before it ever gets to the point of filing a civil lawsuit in a case like this. So I'm going to keep an eye on that. We're going to keep watching that as well. Something else you want to break me down? I appreciate you guys watching these videos, and next time I'm gonna do this from my bathroom again. Thank you very much.